Now, let's take a look at Tennessee marriage laws. Okay, we've already put this up there, but let's work through this for just a moment. Here's the statute we've already looked at. It says that to get an application, no clerk can issue an application unless it has the name of a male and female on it. So if the words male and female are invalid, which is what the Supreme Court said, right? They said state laws that exclude are invalid. Then what words took their place? There's the statute. There are the words male and female. If those words are invalid, what words took their place? Who can be the contracting parties now? And who can insert words in a statute? Well, let's take a look at that for a moment. Under the state constitution, only the General Assembly can prescribe the duties of a clerk. The Constitution of Tennessee says the qualified voters of each county shall elect for terms of 4 years a county clerk. Their duties shall be prescribed by the General Assembly. They're not prescribed by the governor. They're not prescribed by the Supreme Court. They're not prescribed by Congress. They're prescribed by the General Assembly. If the General Assembly passes no laws giving the clerk anything to do, then the clerk gets elected every 4 years and sits at home. They sit at home because there's no duty, so there's no budget, so they can't even have an office to go sit in. On the basis of what law passed by the General Assembly can a clerk issue a license to anybody if the law is invalid, which Obergefell held? On the basis of what law prescribed by the General Assembly are our county clerks issuing any marriage licenses to anybody? Well, okay, what law? What's the law? Where is the law? Let's find it. You remember the little Wendy's commercial, those of you in the room that are over 50s? Where's the beef? Where's the beef? Remember, well, where's the law? I want to see the law. Where's the law? Well, there are two answers to this question as to how the clerk can be issuing licenses. Again, here is the statute. And the question would be, well, can you just simply elid, that's a nice legal word we use, or delete, the words male and female, and then interpret the remaining words, contracting parties, to mean any two people regardless of their sex? So as you see in the statute, if we just take the words male and female out of the statute, it says the security number, the names and so on and so forth of the proposed contracting parties. Well, that's the law. There it is. That's it, Dave. You just take those words out. Well, there's a problem with that. Interestingly, the two cases that dealt with in-state marriage license laws, Michigan and Ohio, both have references to man, woman, or male, female. And the court did not analyze those statutes. It's very interesting. They didn't say, well, here's the statute, and here's what you do. You just take the word man and woman out, and voila, you have the rest of the statute, and that's how you get married, holding number 2. There's the law. They didn't do that. Very interesting. In most cases, like in abortion cases where there's a provision about the doctor doing something or whatever it is, they quote the statute and they say, well, here's the key word, and you take the word out and all that, and they interpret the statute. They didn't do that in this case. Why did they not? Why did they not? Why didn't they tell us, here's how you get to this new law? Other than just saying, you can get married, why didn't they say, well, here's how? They didn't explain it for us. Well, let me tell you why they didn't. There's this doctrine of elision. The United States Supreme Court has cases that are exactly like this. They use the word separability or severability, which is the concept of can you elid, can you separate, can you segregate out invalid words, unconstitutional parts, and just uphold what's left. The Tennessee Supreme Court last March said, when a conclusion can be reached that the legislature would have enacted the act in question with the unconstitutional, the invalid, part omitted, then elision of the unconstitutional portion is appropriate. In other words, here's the question. When I said, can you just take the words male and female out of the statute, the question is, well, if the legislature had passed it without those words, if those words were removed, would the legislature have enacted the law anyway? Well, do you think when the General Assembly passed the law in 1995, it would have enacted it if the remaining words, contracting parties, could have included 2 men or 2 women? Now, before you answer that question, let me tell you that sodomy was a crime. Would the legislature have authorized a marriage that would have been a crime to engage in? Now, they do some crazy things, but not that crazy. How do I know that for sure? Because I voted for that law in 1995. It was my first year in the General Assembly. In 1996, the State Court of Appeals said your sodomy statute is unconstitutional. It's unconstitutional to make sodomy a crime. You know what we did in 1996? We passed the Defense of Marriage Act that said, hey, in 1995, we said you had to be a male and a female, and in 1996, the next year, we came back 4 months after the Supreme Court, or the court struck down our sodomy statute and said, by the way, we meant man and woman. We really did mean that. How do I know that? Because I voted for it. I was the one defending it on the floor. The answer to this question, can you take the words out, is no, no, no. It would have never been passed. Why did the Supreme Court not go through this analysis? Because they would have known the answer. Nobody would have passed these marriage statutes at the time they passed them if it was going to allow same-sex marriage. Their own court precedent would require them to say the whole statute's unconstitutional. You can't just take those words out. So they just kind of over it. Said, we're not going to get into it. We're not going to explain it like we might normally because we'd get in trouble. We'd have to start overruling years and years and years of precedent on whether you can take words out of a statute. So there's that answer. Well, what's the other answer? Okay, we're issuing marriage licenses. What's the law? Well, here's a second possible answer. What did the court say? The court said, we hold same-sex couples may exercise the right to marry. So the Supreme Court just passes the law. Your law is invalid. It's gone. It's unconstitutional. You can't elide and delete the words male and female and save the statute. It's just gone. So we'll just pass a new one for you. We'll tell you what to do. The problem, my friends, is that's the court effectively enacting a new marriage license law to replace the one it said was invalid. And that's a violation of federalism and the separation of powers. That is an unconstitutional act by the United States Supreme Court, contrary to its own cases, upholding the doctrine of federalism, NFIB versus Sebelius, and separation of powers.